thank you very much for joining us today. My name is Ian Scott, and I am the founder of Scott Legal. Our firm is an immigration and business law firm, and we provide a wide range of immigration services, and we process really all types of different visas. Today, we're going to spend some time talking about some visa options for entrepreneurs, and specifically, we're going to talk about the E2 visa. We're going to go over the E1 visa, the EB1 visa, the national interest waiver, EB2 visa, and the EB5 visa. And we're also going to talk about some other, maybe I'll call them non-traditional visas that entrepreneurs might consider. A few things that I just want to go over before we get started. So some of the visas that we talk about, I personally am very familiar with. That is the firm actually was founded on an E2 visa, and I'm in the U.S. on an E2 visa myself. So if you have any specific questions about my own personal experience, happy to answer those questions. We will continue our webinar series. We have a number of different webinars coming up, and we have at least 2 webinars a month on different topics. And we have one coming up, or 2 coming up actually next week. One is on green card options for entrepreneurs, and then the other one is on E1 visas. So we'll hear a little bit about E1 visas today, but that'll be a more comprehensive summary of the E1 visa requirements. We also have more seminars in February and March. We have more on E2s. We have an H1B seminar. We have an E3 seminar. So a number of different topic areas that we are going to cover. So after the webinar, we're going to send you a number of different things. We're going to send you this PowerPoint presentation. We're also going to send you a couple of guides. So we have an E2 guide and an E1 guide. So those are 2 of the visas we're going to talk about, and we're going to send those to you. And we're also going to send you a link where you can sign up for additional webinars. So down to our panelists today, we're lucky to have Kelly Legrand-Wiener here, who's a managing attorney of the firm, and Michaela Vrazdova, who's an associate of the firm. Both of them have experience processing all of the visas that we're going to talk about today. And again, my name is Ian Scott. I'm the founder, and I will also be the moderator today, and I will present 1 or 2 of the slides as well. In terms of questions, to the extent that you have questions as we go through, please add them to the chat box or the question and answer box. We will get to all of your questions. Some people have sent in questions in advance as well, so we'll ask those questions as we go through the presentation. And finally, the webinar will be available on demand after. So this is a recorded session, and it will be available to you after the webinar. So without further delay, we are going to start the presentation. But before we get into the specific topics, I want to ask Kelly a question. And the question really has to do with the idea that we have an entrepreneur, there are going to be some entrepreneurs on the telephone. They might be in their home country. They might be in the United States. And, they're entrepreneurs and they might want to get things set up in the US, but they don't have a visa yet. And could you just talk through some of the considerations that, some of the things that they would consider and some of the options that they have to get things ready for something like, for example, the E2 visa or another visa that they might be eligible for?
Sure, absolutely. Perfect. So one visa that is good for this type of setup is the B1 business visitor visa. So this is something that, some people already have in their passports. They might have a 10-year B1, B2 visa that they used for tourism in the past. Canadians specifically are visa exempt. So whenever they enter, they can enter as tourists or they can enter as business visitors. And the B1 status, you can get status in the US for up to 6 months. If you're coming on ESTA, ESTA is similar. It means the same as a B1, B2. And the business visitor visa, it doesn't allow you to come and work in the United States. But what it does allow you to do is to specifically explore investment opportunities. So for example, if you have a business broker that you want to meet with, if you're thinking about buying a company and you want to come and meet with the potential seller, if you are interested and you want to just check out a local market, maybe do some market research, the B1 is really good for all of those things. Additionally, if you're kind of farther down in your planning and you actually want to come and open a business bank account, actually set up your office, scout office locations, sign a lease, meet with potential clients. The B1 is appropriate for all of those things. So that's a really good option, I think, for people who are, investigating or a little bit farther, know they want to do some type of business or work visa in the United States, and they need kind of a temporary visa to allow them to come. You do want to make sure that you're, within the bounds of what's allowed on the visa. So you're not allowed to kind of come, set up your company and start working. But there are many things that you are allowed to do that are critical for entrepreneurs who are investigating, starting up their companies in the United States.
Perfect. No, thank you. Thank you very much, Kelly. And Kelly, you may have mentioned it, but if someone enters on ESTA, can they just, is that just a tourism visa, or can they do things on that?
ESTA can be for both, but it depends what you say when you come in the border. So when you enter on an ESTA, you'll get an I-94 after you enter the United States, and it will be marked B1 or B2. So if when you come in on your ESTA, you say, I'm here to investigate some business opportunities, then they should mark you as a B1. And then that's when the business visitor activities would be appropriate.
Perfect. Excellent. Sounds good. And that then brings us to the first visa category for entrepreneurs that we're going to talk about. And that's going to be the E2 visa. And we're going to turn it over to Kelly again to give us go through those requirements.
Perfect. So the E2 visa, which is a visa that we do a lot of, as Ian said, he is in the US on an E2 visa. It's a great visa for entrepreneurs. So it's probably one of the first visas, or if not the first visa that comes to my mind when someone says they want to open a business in the United States. So the first thing that is required is that you have to be a national of a treaty country. There's approximately 80 countries on the list. Some common ones: Canada, the UK, Australia, Thailand, South Korea. Recently, Israel and New Zealand were both added to this list as well. And actually, a few countries were removed. Bolivia, Ecuador, and Iran were all removed from the E2 list. So if you are a national of a treaty country, then the E2 visa is potentially available for you. Unfortunately, if you are not a national of a treaty country, then this may not be, this would not be an option. Some people do kind of are able to get different nationalities, so we have many clients that maybe, had Indian nationality, maybe now they moved to Canada, they got their Canadian citizenship, and now they're eligible to apply for an E2 visa. So the main requirement is that you have to invest. So you have to make an investment and actually put your money at risk, and it must be irrevocably committed. And what this means is that the E2 visa doesn't allow you to just set up a business bank account and put money into it. That money actually has to be spent on investments to set up the company. And you have to be able to provide a legitimate source of funds for that investment. So for example, if you have personal savings and you want to invest that into your company, then that's a good and clear source of funds for an E2 investment. Similarly, maybe some of our clients may sell property. Additionally, you can get a gift from somebody if they're able to show you where they have that source of funds. One limit is that you cannot take out a loan that is secured by the assets of your E2 company. So loans may be okay for a source of funds for investment, but a loan secured by the E2 business would not work. So for the investment piece, the other thing you have to consider is your investment substantial? And what is substantial is going to be based on a proportionality test. So we have to look at what are the total startup costs for your type of business. So if you have a consulting or service-based company, for example, a law firm, your total startup costs might be quite low. You might be able to reasonably argue that you could start up the company by investing somewhere around $60,000. Even though this is considered a low investment, there's a pretty reasonable argument that that investment could get you up to what you need to actually open the company. You don't have to spend the entire $60,000, but the more that you can spend, the better. So you might want to spend about 30, 40, 50,000 of that investment, to prove that it's substantial. But you have to consider what type of business you're setting up. So if you're not setting up a business like a law firm or service-based business, let's say you're setting up a business like a manufacturing company or a business that has extremely high overhead, that's a type of business where the amount of your investment will need to be much larger because what you'll need to get yourself to starting the company is just you're not going to be able to argue to an officer that you've invested everything needed to set up the company for a manufacturing company if you don't have a warehouse, inventory, equipment, all those things. Um,
So Kelly, for the investment or the businesses that are more service oriented and have lower dollar amounts, what are some of the things that people can spend money on?
Sure. So I'd say typical expenses are, one is business entity setup fees. So fees you pay to a state government to set up your company, setting up a website, purchasing office supplies, purchasing inventory, any equipment that you need to run the company, any rent. So rent for an office space, rent for warehouse or storage space, any marketing expenses that you have, legal fees as well can also be included in the investment amount.
Perfect. Now, so another question that came in had to do with what can an individual do if they, if someone does have a low investment amount, what are some other things that they might be able to do to strengthen their case?
Sure. So if you have a low investment amount, you want to make sure that you're including information that shows the company really is viable. So certain things like proof of contracts or letters of intent with potential clients, letters from a chamber of commerce, indicating that there's supportive business organizations for your company. Additionally, if you hire someone in the U.S., that gets really, really positive for your application. One of the main goals of the E2 visa is to facilitate, investment and trade between the U.S. and the treaty countries. So any hiring that you do is very positive for the application.
Perfect, perfect. And the one of the expenses that you mentioned in terms of the standard expenses was a lease. And could you talk about that? And is it really required, especially now, like with COVID and things like that, and people working from home? Can people just forego the lease now?
So we tend to recommend to our clients that they get a lease. We think it strengthens the application. There are some times when a lease would absolutely be required. If you're opening up a restaurant, you need a lease. There's no way to argue around that. If you're opening up a doctor's office, a chiropractor's office, you need a lease. There's the business, the type of business you're opening is fundamentally tied to the lease. For service-based businesses, there was a recent change in the regulations that actually specifically mentioned that no physical office space was needed. So it is possible to try to argue that office space is not needed, particularly in light of where we are, with the coronavirus. However, I would say that a lease is a really strong factor for your application. And if you are able to have a lease, we still do generally recommend that you get one, even if it's not explicitly required, if your business is not the type that requires it.
Perfect, perfect. And another question that came in had to do with the what you spend the money on, and you gave a number of examples, but can the person just spend money outside of the US? Like, so can they buy inventory from China or Italy or some other place and then ship it to the US? Is that okay?
So that is okay. There is no requirement that you have to spend the money in the United States. Technically, the investment could be entirely outside the United States. However, recently we have seen some consular officers start to ask our clients about this and say, well, how much was spent in the US? So this isn't a requirement in the regulations, but it is something that we're starting to see consular officers looking at. So we do recommend, if at all possible, even though yes, you can include money you spent outside the US, if you're able to spend some money inside the US, that's also strong for the application.
Perfect, perfect. And the other question, and this just popped into my head as I was making a video about this topic today, as a matter of fact, but I'll ask you the question. The change in administration, what do we see any do we expect any changes to the E2 visa based on this the new administration, the Biden administration coming into office?
We really don't. I think, the E2 visa, some visas were very impacted under the last administration. The E2 visa was really not one of them. It continued to be processed, cases continued to be approved at the consulates. The standards didn't really change, although there was an introduction of something called the Buy American, Hire American executive order under the old administration that caused more of a focus on US hiring. It really didn't have a huge impact on the E2 visa. And we expect that there'll be more of the same under the Biden administration, in the sense that E2 visas will continue to be processed and continue to be approved, under the same standards.
Perfect. No, that sounds great. And with E2 employees, could you talk a little bit about them? And do they have to be citizens? Can they be part-time? Can they be contractors? What?
Sure, perfect. And this is actually perfect for the next thing on the slide, which is, marginality. So, an important part of the E2 visa is hiring employees, in the United States. These employees don't have to be U.S. citizens. It is true that on your application, you will mark down eventually kind of which of your employees are U.S. citizens and green card holders, which are nationals from third countries, which are nationals from, who are E2 employees. But any employment is going to meet the marginality requirement if it's located in the US. So if you have people in the US, it is true that I think the officers do, they like to see that you've hired, US citizens and green card holders, but it's not a requirement. But it's a requirement to hire employees. You should definitely hire employees, but you don't have to hire US citizens specifically, as long as you have some employees in the United States working for the company.
Perfect. And is there a set number that they have to have?
There isn't any set number. We generally recommend that by 5 years that you have between 3 to 5 US employees, preferably full-time. You can have less than that, but again, it weakens the case. So if you have a lower number of employees, you want to have an explanation for that. Sometimes some companies, their model is that they have many, many 1099s, particularly construction companies. They may often work with subcontractors. In that case, if you're paying a lot of money to subcontractors, that's the type of thing that we would mention in the application. But we generally still recommend that you have, at least 1 or 2, full-time employees. It just makes the case stronger.
Perfect. Great. Thank you.
Perfect. So just to return to the requirements. So another requirement besides investment and marginality is the business must be real and operating. And what this means is that you have to show, if the business is already running, you're purchasing a business that is already operating, then it's very clear you'll be able to provide tax returns, W-2s, perhaps a sample of business bank statements showing revenue, invoices, anything to prove the company is actually running. If you have a startup, which is also very common, then what you want to show is that the business is ready to start operations as soon as you get your visa. So, for example, if you have a pure startup, if you do have a lease agreement, if you do have kind of contracts or letters of intent that are already ready, often now they want to see an operating website, and the idea is to show the officer that when you come into the United States, your business will be ready to operate. For example, we had a client who started a gym. The officer asked her, well, if I looked at your gym, your leased gym, what would I see? And she was able to say, the equipment is there, it's in the gym. All that's really needed is for me to come turn the lights on, and open the company. So another requirement for the E2 visa is that you as the investor must be coming to develop and direct the E2 enterprise. And so for this, what they want to see, I'd say the strongest cases are ones where, you've worked in this industry before, you've done this type of work before, or you're someone who has held executive or managerial jobs. So you know how to run a company on the business side of things. And you would demonstrate that you are planning to come and run the company, and that your goals will be kind of on the level of somebody who is designing long-term strategies for the company and overseeing how it's going to run, hiring and managing employees, things like that. Additionally, if you are the investor, you have to own at least 50% of the E2 company. And nationals of the treaty country have to own at least 50% of the E2 company. So very often for, new entrepreneurs, they may own 100% of the company, or they may have a business partner. If they do, that's fine, but the business partner cannot own more than 50%. You have to have a 50-50 split in order to qualify for the E2 visa. And then additionally, the E2 visa is a non-immigrant visa. That means you have to have intent to return to your home country. The standard for this, I'd say, is quite low. Normally for E2 visas, you can just submit a letter that says you intend to return to your home country upon the expiration of the E2 visa. You're allowed to move your entire household to the United States. You don't have to prove that you're maintaining a household abroad. So the only time that this might become an issue is if you have a lot of red flags, such as you have an immigrant visa pending and the date for getting that immigrant visa is coming up very soon. So, those are the types of things you could discuss with Immigration Counsel, but most of the time, just signing a letter confirming that intent to leave at the end of the E2 visa will be, sufficient. And additionally, even though you sign this doesn't prevent you from renewing. E2 visas can be renewed indefinitely. There is no limit on the amount of E2 visas you can get as long as you and the company continue to meet the E2 requirements. That is, I'd say, the E2 visa.
Excellent, great. Thank you very much. Thank you very much, Kelly. And the next visa that we're going to move to, it's the brother or sister, I'd say, of the E2 visa, and it's I think the brother or sister that's not liked that much, but is actually very nice because it's a visa that I think is underutilized, but it's a great visa after when you put an E2 visa, an E1 visa side by side, often if the person's eligible for both, the E1 might be preferable. So with that, we're going to turn it over to Michaela to go through the E1 visa requirements.
Yes, so the E1 visa is a non-immigrant visa that allows traders who engage in substantial trade between the US and their home country to come to the US. So there are basically two scenarios when someone can qualify for an E1 visa. So the first one is for example you own a business in your home country and you are selling products or providing services to clients in the US. So for example, you have a business in your home country and you are selling for example a furniture to clients in the US. So that would be kind of like trade of goods. And the second scenario would be if you have a business in your home country and you are providing services to clients in the US. So that could be, for example, providing consulting services to your clients in the US. And the second option, how you could qualify for an E1 visa, is if you, for example, already have a company in the US, but you are still living in your home country, and now you want to move to the US and kind of like manage the E1 company or E1 business from inside the US. And in that scenarios, we would still have to show that there is international trade between the E1 business and your home country. And so that could be, for example, if you have an E1 company in the US, that is, for example, selling, custom-made suits to US clients, but you are, purchasing the fabrics from your home country. The international trade would be, purchasing the goods from your home country. So these are, the two typical scenarios of how someone could qualify for an E1 visa. And now I will go quickly over the E1 visa requirements. So similar as the E2 visa, for you to qualify for an E1 visa, you have to be a national of an E1 treaty country. And there are approximately 60 countries on the list of E1 visa countries. So for example, countries in Europe, Africa, Latin America, Asia are listed on the list of E1 visa countries. The second requirement is that you must engage in activities that constitute trade. So as I mentioned, for there to be international trade, you must either be selling or buying, goods or services. There must be a trade between your home country and the US. And the trade, it can be a trade of goods or a trade of services. So as I mentioned, you can be, for example, purchasing, furniture, computers, materials, or things like that. Or you can also be providing services, to your US clients. Then the second requirement for the trade is that the trade must be identifiable. So it must be clear to the consulate there is an ongoing trade between the US and your home country. And so what this means is that, we would have to submit evidence such as, invoices, bills of lading, US custom documents showing that the goods are coming to the US, or companies' bank statements to show that there is ongoing trade between the US and your home country. And the third requirement about the trade is that the international trade must be already in existence at the time you are applying for an E1 visa. So there is one exception to this rule, and the exception is that the trade doesn't have to exist, but you have to have a binding, successfully negotiated contract with clients. And I would say generally we advise clients that at the time they are applying for an E1 visa, the E1 trade is already existing. But if you have, let's say, 50 signed contracts with US clients for kind of like high monetary value, you could potentially qualify for an E1, even though, there is no trade existent at the time, you are applying for an E1 visa, but there will be a trade in the future. Then the next requirement for the E1 visa is that the trade must be substantial at the time you are applying for an E1 visa. So we often get asked, what does substantial mean, and how much trade there has to be between your home country and the US. And unfortunately, the E1 regulations kind of do not provide specific number of what is substantial trade. But the consular officer will basically look at how many clients you have, how many kind of like transactions there are, per year with each client, and what's the monetary value of the trade in general. So we generally recommend that the trade is at least around $250,000 per year. That is kind of like a general rule of thumb, of what trade is substantial, but it will also depend of the type of business you are conducting. The next E1 visa requirement is that the trade must be principally between the US and your home country. So what this means is that the international trade must be, at least 50% with the US. So let's say, for example, that you own a business in your home country, and 10 million euros per year you are kind of trading with the domestic companies in your home country, and then let's say 2 million euros is a trade with the US, and you are not trading or selling products to any other international customers, just US customers. So in this case, the domestic trade is not counted in this analysis. So in this case, you would meet the requirement that the majority of the international trade is with the US, because in this case, 100% of the international trade is with the US. And one thing to keep in mind here is that the majority of the trade must be with the US at the time you are applying for an E1 visa, but this criterion have to be kind of satisfied throughout the validity of your E1 visa. So the international trade can kind of like never drop below 50% and must always be at least 50% with the US. The next requirement is that, if you are applying for an E1 visa, you must be coming to the US to kind of solely engage in substantial trade. And what this means is basically that, you are coming to the US to kind of manage the E1 business. And the last requirement is that because E1 visa is a non-immigrant visa, you must have intent to return to your home country at the time your E1 visa expires. And the standard here is the same as Kelly mentioned for the E2 visa. And what is usually sufficient is that you submit a signed declaration that basically says that, once your E1 visa expires, you are planning to return to your home country.
So Michaela, let's look at a scenario. So let's say that a company exists in Italy, for example, and the company makes furniture and they ship that furniture to the United States, and they want to now transfer someone to the United States. So I guess they have two options. They have the E1 possibly if they meet these requirements, but they also have the E2 because they are going to go to the United States. Maybe they're going to make an investment, etc. So what are the reasons someone might choose an E1 over an E2?
Yeah, I would say in most cases when a client qualifies, for E1 and E2, most people prefer E1s, and the reason is basically that for the E1 visa there is no requirement of an investment in the US, so no money has to be kind of like spent in the US to kind of like set up the business. And the second kind of advantage of the E1 visa is that the E1 business doesn't have to hire employees. I would say normally the business will have some employees anyway, and the business will kind of spend and invest some money in the US anyway, because office has to be set up and things like that. But there is no requirement that certain amount of money has to be invested, and no US employees have to be hired. So I would say those are kind of like the biggest advantages of the E1 visa, and many people just prefer that they don't have to invest money in the US and just kind of like start the E1 company without investing the money, and kind of have to employ like certain amount of US employees.
Perfect. No, that sounds good. And this question, and I think it applies to both E1 and E2. But when someone gets this visa, how long can they come to the US for?
Yeah, so both E1 and E2 visas. So it will depend on the country you are national of. So each country has kind of like different amount of time. They allow you to stay in the US on either E1 or E2 visa, but it it can be anywhere from couple months to up to 5 years maximum. But it's kind of like country specific.
Perfect. That sounds good. And the last question has to do with employees. So if someone's working, that same example where someone has a company in Italy and they have their right hand person that they want to bring to the United States as well, and let's say that person is from France, can they bring that person as an employee?
No, so if a business is kind of like based in Italy, the company can kind of like register the business as an E1 business and then bring to the US E1 employees, either on managerial, executive, or kind of like specialized position. But the business will kind of have Italian nationality, E1 Italian nationality. So there is, unfortunately, no chance to bring, someone from France under E1 visa, but there may be other options like, H1B visas or green card options, how to bring that employee.
Perfect. But they could bring someone from Italy if they wanted.
Yes, exactly.
Okay.
Yeah. Mm-hmm.
Excellent. No, great. Sounds good. Perfect. No, that sounds good. Well, that's the the E1 and E2 visas in a nutshell. And the next visa category that we're going to move to, and this one we're not going to spend. It's kind of two similar visas. One's a non-immigrant visa, and one is a green card. But this one we're not going to spend too much time on because it is a category that's available for entrepreneurs, but I would say that it's not one that is often used for entrepreneurs. But we thought it was worth covering, and Mikhail is going to go through this one.
Yeah, so I'll just quickly go over this. So the EB1A green card is a green card for someone who has extraordinary ability in a certain field, and one of the fields that is kind of mentioned in the regulation is a business. So if you are if you have extraordinary ability in business, meaning that you have sustained either national or international acclaim, and that you are in the very top of your field, you could potentially qualify for the EB1A green card. And so the EB1A is a green card, and then similar non-immigrant option is an O1A visa. So the O1A visa is a non-immigrant visa, meaning that your stay in the US is limited. But the EB1A green card is a green card, meaning that you can kind of like permanently move to the US. And the requirements for the O1 and EB1A are very similar. So I'll just go over them in general. So in order to qualify for the EB1A green card, you must have won either a kind of like a major international prize, like a Nobel Prize, Oscar, or some prize that is like the most precious or important prize in your field, or you must meet 3 of the 9 requirements that are listed in the PowerPoint. And I highlighted 4 of them because I think the 4 of them are kind of like most relevant for, you know, people, for entrepreneurs who want to come to the US. So one of the requirement is that, you know, you have been kind of like judging the work of the others in your field. So how you can meet this requirement is that, you know, you will submit evidence that you have been participating as a judge at, you know, prestigious competitions in your field. And what we usually submit here is to kind of is a letter from the, you know, the association or the organization that invited you to judge, and the letter will basically explain, you know, why they chose you to judge this competition. And it should basically say that, you know, you have extraordinary ability in your field, you are in the very top of your field, and that's, you know, that's why they chose you to judge the competition. Then the second requirement or the second criteria you can meet is that, you know, you have made an original contribution of major significance to the field. So here, you know, people who kind of like have patents, or who kind of like discovered or came up with new business protocols or strategies could qualify under this criterion. And here, you know, as evidence, we would basically be submitting, you know, if there are any media articles kind of describing your this major contribution, or perhaps letters from experts in the field that kind of discuss, you know, this original contribution you made. Then another kind of like criteria you could qualify under is that, you know, we would basically be submitting evidence showing that you have been working in a leading or critical role, you know, for a distinguished organization. So for example, if you have been, you know, working as an executive for kind of like a really famous company, we would be basically submitting a letter from the company kind of describing what you have been doing for the company, and also evidence, you know, why this company has distinguished reputation. And kind of like the last relevant criteria here is the salary. So if you have been earning kind of like a really high salary in your field, we could also submit that as an evidence that, you know, you are in the very top of your field, and you qualify for an EB-1A green card. So now how you can apply for the EB-1A green card. So either if you have already a job offer in the US, you know, your US employer could sponsor you for the EB-1A green card, but you could also self-petition yourself. So you do not necessarily need a job offer from a US employer. And that's why kind of like many people like to go the EB-1A route, because they don't need a US employer, they don't need a job offer from US employer, and they could just self-petition themselves, you know, explaining why they qualify for the EB-1A green card, and kind of describe why they are coming in the US, and like what they will be, you know, doing in the US. With regards to kind of like the EB-1A procedure, so you first have to file what is called an I-140 petition that has to be approved by USCIS. And you know, when this is approved, you know, you can file the green card petition. If you are already in the US at the time, you know, you are applying for an EB-1A green card, you can adjust your status from within the US. Or if you are outside the US, you can file the EB-1A green card as a consular processing.
Perfect. No, that sounds great. No, thank you very much, Michaela. And the next visa category that we're going to talk about is another one I think that's underused for entrepreneurs, but really an excellent category, and something that became available within the last few years, really. So Kelly is going to go over EB-2 National Interest Waiver.
Yes, so yeah, so the national interest waiver category, really in 2017, there was a radical change, I'd say, to the standard of this category, which made it a lot friendlier for entrepreneurs. So that's the case that we've listed, you know, on the slide, which is matter of Danazar. And before we get to that standard, I just wanted to briefly go over, threshold considerations for the EB2 category. So when you're looking at, is this a good category for me? You want to first consider, do you either have an advanced degree, master's or higher, or an equivalent to that, which would be a bachelor's plus 5 years of post-baccalaureate progressive experience in the field. So it's, if you're going to kind of do the qualifying for the master's on the bachelor's, you want to look at that. Or you can have exceptional ability. You could show that you meet 3 of several criteria to prove that you have exceptional ability. So if those, you want to consider, do you meet either of those 2 things? And if you do, then this is a good category for you. And it's a great category for entrepreneurs because under the the new standard, what you need to do is show that your proposed endeavor, so your business or, whatever business you're starting, has substantial merit and national importance. So for entrepreneurs, employment, jobs are certainly something that, can, I think, easily be argued has, national importance to the United States. This is particularly the case right now. Strong economic impact of kind of job creation is a really important thing for entrepreneurs. Additionally, you have to show that you as the entrepreneur are well positioned to advance the proposed endeavor. So, things like your resume, your degrees, your background, how is it that you and why is it that you are the right person to advance whatever kind of business it is that you're running. And then the last requirement from Dan Azar is that on balance, it is beneficial to the United States for them to waive the labor certification. And what this means is that, normally if you want to get a green card under the EB2 category, there has to be a US employer that's going to test the labor market and say, hey, are there any US workers that can do this job? So under this category, you're basically saying, you should waive that requirement. And it works well for entrepreneurs because entrepreneurs, majority owners of companies, are really not eligible to get the EB2 under the normal perm process. So when you're arguing this to the government, you can say, my company that I'm starting is going to have, job creation. There's going to be a strong economic benefit, to the community. You can talk about whatever type of business it is that you're actually running. So beyond just the job creation, if the company also has some other type of work it's doing that could arguably have, substantial merit and national importance, you can argue for that as well. And because it is that you are the majority owner of this company, it's not appropriate for you to have to go through the labor certification process. So that's kind of the basic new structure of Danazar. And it's something that is, as Ian said, still somewhat underutilized, but there have been, a few cases that have been decided since 2017 that really show that, the direction of this visa is for people who are, are starting companies in the United States and are, creating jobs and having a really strong, economic impact on the United States in that way. I think you're muted, Ian.
Sorry, perfect. One of the threshold questions someone asked Kelly, and I think it's a clear answer, but they just asked, does the advanced degree include a master's degree, which I think it does.
Yeah,
so,
yes, a master's. Mm-hmm.
Perfect. So in terms of what are some of the things that you'd expect, like for an entrepreneur petition, what are some of the things you'd expect to see in the expert letters, for example? What types of things would the letters maybe talk about for an entrepreneur?
So for an entrepreneur, I think you would include well, first of all, you'd include the expert letters would really talk about what is the benefit of your business to the to the community that you're serving. So if you want to look at unemployment statistics for that area, and if there's high unemployment and the company is something that could do that. Similarly, the letter should really focus on why is it that your company has national importance and substantial merit. So that could address both the economic benefit of bringing a new business that's going to have job creation, as well as what is it the company is actually going to be doing, what community are they going to be serving, and why is that something that's has substantial merit and national importance.
Perfect. No, that sounds good. And is this a petition? Do they have to get an employer? What do they need an employer to do this?
They don't. So it is similar to the EB1A. You can self-petition. So that's, you know, a nice benefit of the EB2. So you could have, you know, if you have your US company, you could have kind of that be the US employer. But many EB2s will in fact just self-petition. It gives them kind of more flexibility in what they're doing.
Perfect, perfect. And I know you mentioned that resumes and degrees are going to be important for this second prong. Is there anything else that they should look for?
Yeah, so the second prong really addresses, you know, how are you as the applicant well positioned to advance your endeavor? So besides your resume and degrees, if you have a record of success in similar or related types of businesses, if you've had successful businesses in the past, you also want to include a strong business plan that shows here's what my plan is, here's who I plan to hire, here's why I have a path to success. Any proof of interest that you have from potential customers, investors even, or other relevant business organizations or even philanthropic organizations in the area that kind of speak to your expertise and your ability to run the company. All of those things are very helpful to help show why, you know, you are somebody who is, you know, the right person to advance this, you know, this important endeavor.
Perfect. No, that sounds good. And the other, if someone was in the U.S., like let's say that they were, you know, on an E2 for a while, for 10 years or something like that, and they have an established business in the U.S., can they apply for this visa?
They can, yeah, they absolutely can. You know, they can show that, you know, how they've met their business plan, particularly for E2s. E2s already, you know, have the requirement that there needs to be employees. So ideally, by the time you applied, you know, for the EB2, you would have a strong record of job creation. And if the business has been doing well and consistently hiring employees, then that would be, you know, a great case, I think, to show that, you know, this business is something that can really succeed and have a strong impact on the U.S.
Perfect, perfect. And one question that just came in, the question, I'll just read it. Is economic impact the only measure for national importance?
It's not. No, I'd say that it's we've been focusing on it right now because that's really what a lot of entrepreneurs will do. But it's much more expansive than that. EB2s, you know, prior to the Danazar case, I think really when people thought about EB2s, there was a lot of kind of you know, doctors, you know, cancer researchers, people who are doing kind of breakthroughs in that area. But economic impact is just one of the ones that would always be included from an entrepreneurial perspective, because that's something that you know, the company would be doing. But it certainly is much more expansive than that. You know, anything that you can argue that has substantial merit and national importance to the United States could be, you know, could help meet this requirement.
Yeah, and I think it's a good point. I think that you can argue, you know, more than one thing as well. Like you can argue that there's an economic benefit of employment or economic activity, but then you can also argue, let's say that the company is manufacturing something that the government finds is important. Then you could argue that that's in the national interest as well as the economic impact. So so I think that as many things as you can argue to drive home the fact that this business is in the national interest, you would definitely you would definitely do that, because you're not, the one great thing about this category, it's not like the EB1 category where you really are limited to the 8 or so criteria that they list. There are 3 prongs, but how it is that you get to those 3 particular prongs, you know, there often are many ways to do that. So perfect. And let me just see if there are any other questions here. I think that was it. Yes, perfect. Okay. Yes, no, sorry. One last question that someone had sent in before. How long does it take? And can the person, like, let's say that someone is here in the U.S. on an E2 or an O1 or some other type of visa, can they remain in the U.S. while they're waiting for their response?
Right. So the way that it works to, you know, to file this petition is that you would file an I-140 petition and an I-485 petition, a green card petition at the same time. When you file the green card petition, you know, that gives you the ability to remain in the United States. This particular category, you cannot use premium processing. So there's no ability to kind of get an answer on the I-140, the first part, within the 15 calendar days. Right now, processing times for the I-140, so that first part proving, you know, do I meet the EB2 standard, it's really variable. It's between 6 and 18 months, depending on which service center that you go to. So it's taking quite a while. But while you're waiting, if your adjustment of status, your I-485 is also pending, you can remain in the U.S. The entire time. You can continue to apply for work and travel authorization, and those are renewable as long as your adjustment of status is pending. So the whole process, just because of USCIS backlogs, may take a couple of years because they are taking quite a while to process these petitions. But while that's happening, you can, work and work in the U.S. and also have the ability to travel internationally as long as you're continuing to renew the work and travel authorization in a timely manner.
Perfect. So I'm going to, there are two questions that came in. One, I'm going to, Kelly, as I go through EB5, if you could just take a look at it, and once I'm done, you could just answer it. It's in the chat box. But then the other one relates to this, and I'm just going to read it and answer it relatively quickly, so we can move to EB5. So how do they define economic impact? How much revenue the business needs? How much revenue does the business need to have, and how many employees? So I think that it's not going to be a satisfying answer, but it really depends on the type of business. So this, if you're solely using the basis that your business is creating jobs as the economic impact, then I believe you would be looking at a large number of employees, like maybe over 50, like your business plan, projecting a very large number of employees. I think that could be a lower number because these petitions, they're not as kind of, 1 + 1 = 2. They're looking at all of the elements that you're putting forth and all of the description that you're using as to why why this business is in the national interest, or why your contribution is in the national interest. And it would be rare, I think, that the only contribution, it has to do with the number of employees, because often there's going to be all of the entrepreneur cases that we've done, there has been a mix between the economic impact of job creation and what the merits, just the substantial merits of the business, because these days people don't just create widgets, right? They're usually what they create, or the service that they're offering has some benefit to the economy or the nation. So I think that it would depend. And in terms of revenue figures, it's just not it would not be a meaningful number. You could have a not-for-profit that qualifies for this particular category. In fact, I believe that one of the seminal cases has to do with a company that, I believe it's a not-for-profit company, but it's a company that provided services to vets. And I don't believe that there was significant dollars associated with what they were offering those services for. But so the revenue is not really a meaningful number. But we do go to 15 minutes after the hour, so we do have some more time for questions and answers. But what I do want to make sure that we cover is the EB5 category. So we're going to move to that right now, and then we'll come back. We'll come back to questions after we go through that category. So EB5, and we're going to talk about EB5 direct. And when I say direct, there's a category, and it's a green card category, that allows an individual to start a business just like the E2, but there are significant differences between the E2 and the EB5. So when I talk about this category, the majority of people who come to the US and apply under EB5 direct do it where they come to the US first on an E2 visa and then change to an EB5. So it's not necessary to do that, but that's typically how it's done. And part of the reason for that is the extremely long processing time associated with the EB5. So often people want to or need to be here to run their business during that time period. So a lot of the references that I'm going to make are going to be from moving from an E2 to an EB5, but just even deciding to do this independently, the rules are going to be the same. So the rules for this program changed significantly in November of 2019, where the biggest change was that the investment amount increased significantly. The investment amount was $500,000 for one category and $1 million for the other category. And that went, and I'm going to describe that in a bit more detail, and that went up to $900,000 for the minimum category and $1.8 million for the maximum category. And what determines whether the amount that you invest there are really two things. So one is if the business that you want to start or want to purchase is in an area that's called a TEA, a targeted employment area, then you can invest the lower investment amount, the 900,000. Or if the business is in a rural area, and the government defines what's considered a rural area based on population, and if the business is in a rural area, then you can invest 900,000 instead of 1.8 million dollars. Now, one of the other significant changes that was made in November of 2019 was that prior to November 2019, the determination of what constituted a targeted employment area was that determination was done by the investor. And the investor, there was a way that you could actually do this where you linked together census tracts, so that even the richest areas in Manhattan, we have an EB5 case that we're doing for someone, and their office is in Soho, but we were able to link together census tracts to so that she only had to invest the $500,000 because we applied before November. But that's eliminated now. So now the federal government is the only group that is permitted to designate where when something is a TEA. So unless you are in an area, and what constitutes a TEA is when the area that your business is in, the unemployment rate is 1.5 times the national average, and the government is going to be the sole determiner of that, and they're not going to do this linking of census tracts together. So if you're in an area that has high unemployment, you may qualify. If you're not, you don't. And the estimate or the determination is made at the time the investment is made. So, and contrasting this to E2 doesn't have a specific investment amount, but EB5 does. So now let's just kind of look at a few other differences between the EB5 investment and the E2 investment. So the EB5 investment requires a personal investment. So this is different from an E2. For an E2, you could, for example, have an investment go through another company. So you could have an individual that invests money into an LLC, which invests money into the US entity. That's completely fine for E2, but it's not for EB5. For EB5, the money has to come from the person to the business. So even a situation where, like, let's say that a parent is gifting a child the money, and the parent, instead of putting the money in the child's personal bank account before the money goes into the business bank account, the parent takes the money and puts the money into the business bank account. USCIS has denied petitions for that because they've said that the investment wasn't a personal investment. The investment didn't come from the individual. So it's very important when you're going through the planning phase, and even when you're looking back, because when you're moving from an E2 to an EB5, it's something that may not always be possible depending how the initial investment was made. So something to consider. The other thing to consider is that, generally speaking, if you do have an E2 visa, you can take a look at the investment that you made in the E2 company, and if you meet the criteria, so the criteria is are a little different. Like, for example, this personal investment, but if you meet the criteria, you can utilize that for the EB5. So the way that the EB5 program works is that the investment that you make, it doesn't have to be a new investment. So you don't have to, say, someone that's deciding that they want to start a company today, and they decide that they have to invest that money today. You can go back to, you can have a company that existed in 1990, and you can still utilize the investment that you made at that period of time, and subsequent investment that you made, and that can all count towards the EB5 investment, provided that it meets the criteria that I'm about to go through. So the second thing that's good about EB5 is that the investment doesn't have to all be cash. So you can consider other things. You can invest equipment, you can invest intellectual property, and that's very similar to the E2 visa. So the two standards don't really differ there. The other thing that I alluded to is the investment for EB5 can be made over time. So we have one EB5 case that we're working on where the individual started their company 20 years ago, and they made a number of different investments over that 20-year period. And we were able to count all of those investments towards the EB5. Now, the one thing that you have to consider when you're doing that, whether you're looking forward or you're going back, is that every single time that an investment is made, in order to keep that TEA status, so whether it was 500,000 or 900,000, the area must be a TEA at the time the investment is made. So let's say that someone is investing 900,000 and they invested in 9 installments over 9 years, or over, let's say, or even 9 months since the change was made. And then one of those months, it just happened that in one of those months, the business was not located in an area that was a TA, because the unemployment rate changes every month. And then they would not get the TA status, and then the investment amount would have to jump up to the 1.8 million. So when you're kind of, especially when you're looking back, like if you're going from E2 to EB5 and you're looking back as to when those investments are made, it's quite an extensive exercise to assess whether or not the areas were TA areas at the time, such that you are able to actually take advantage of the lower investment amount. The other thing to consider is that when you're investing in an EB5, a lot of people kind of have this idea that they have this E2 company. The E2 company is really successful, maybe making millions of dollars, and then they say, well, my business made $2 or $3 million, and I have $2 or $3 million in retained earnings, and that means I'm now eligible for an EB5. And that is not the case. The investment has to be, again, your personal investment. So what the company makes is not relevant. The only way that you can count what the company makes is if the company pays out the money to you, you pay taxes on that money, and then you reinvest the money in the company. So that's the only way that can count towards EB5 investment. The other thing that comes up with EB5 investment, especially for people who are close to the amount, so let's say that you've just invested exactly the 900,000. The other issue that comes up is that any money that's paid to you, so if you paid yourself a salary or you had some type of distribution, USCIS is going to come back later and say that the money that's paid to you doesn't count towards the investment. So particularly when payments made to the individual owners are significant, you really have to go back and make sure that not that 900,000 or the 1.8 million or whatever the amount is, is made up of amounts that are all going to count with respect to the EB5. The other important thing with respect to this is that the E2, the money that is invested can come from a gift or can come from a loan, and the same rules apply. Where the loan can be unsecured. There's a court case that went through an appeal process, but now the rule is that the loan can be unsecured, or the loan can be secured against your personal property, but the business can't be the security for the loan. Similarly, it can be the person can get a gift, but the only difference between EB5 and E2 is that when someone gets a gift for EB5, because the petitions take so long to adjudicate, years, when by the time that the petition is adjudicated, the government is going to ask and make sure that whoever gave you the gift made the tax gift payment in their country. And if they didn't do it, it's going to be a problem. Similarly, if you have some type of loan that you set up, the government has 2 years or so to look back and say, well, has the person actually made loan payments to establish whether or not it's a bona fide loan? None of that really occurs under an E2 scenario, but does occur under an EB5 scenario. So something to keep in mind. The other thing to keep in mind that is, again, similar to to the E2 scenario, is the investment has to be at risk. So you can't have a situation where you take, let's say $900,000, you set up a business entity, you put $900,000 in a bank account and say, I want to apply for my EB5 visa now. That doesn't work. Instead, the money has to be either spent or committed. So, and what that means is that, so for example, one EB5 direct investment case that we're working on, we have an individual, we did an E2 visa for them initially, and they opened up a restaurant. So they took, they applied before the amount went up, and there were two of them that were getting the visa. So they took $1 million, put it in a business bank account. They spent some of it, under 100,000, but then they had firm commitments to spend the rest. So they had a very expensive lease for the restaurant. They had a very expensive contract with contractors that were going to make improvements to the restaurant. So we were able to demonstrate that $1 million was going to be spent in a very short period of time, and that's important. There's a case directly on point where the person did exactly what I described, just put $500,000 in a business bank account, and had a 4-page business plan, and they denied the case. and said that the money wasn't committed. And because really the person could just take the money out, and this in particular becomes a problem if you only have a sole owner, because the owner has the ability just to take the money out. You can reduce or mitigate that risk somewhat if multiple people own the company and you have the corporation has instructions that dictate that the money can't come out of the company. The other the other aspect with respect to EB5 that's very, very important is that the investment has to link to job creation. So this is very, very important. So let me just give a brief example. So let's say that the company created 10 full-time jobs on the E2 visa, and sorry, let me just change the example. Let's say that somebody started a company and they created 10 full-time jobs before they really even made any investment. And then a year later, they decided that they wanted to take it to a new level and they invested 900,000 or 1.8 million dollars. That person can't then say, well, I already created the 10 jobs, because the 10 jobs were created before the money was invested. The money has to be linked to the job creation, so that has to be in a timing perspective and the actual use of the money. So that's something that the government is very, very focused on, and they have a lot of time to be focused on it. So now let us briefly go over the job requirements. So unlike the E2 visa, which has a pretty general job requirement, where we kind of generally say to people, well, if you have 3 full-time people in 5 years, that's probably good or good enough. And you can have part-time people, and you can even have some contractors and things like that. The job requirements for EB5 are very strict. It's 10 full-time jobs. So that means no part-time. It means no contractors. The people have to be US citizens or green card holders, which again, that doesn't matter for E2, or not as important for E2. But for EB5, it's a requirement that they have to be U.S. citizens or green card holders, and they have to work for the actual the entity that you set up. So W2, full-time, green card holders or citizens, and they have to be permanent positions. So they'll even look at the position. So let's say you've hired construction workers because you're building something, and those construction worker, the job's going to be done in 6 months or 8 months or a year. Those aren't going to count towards your 10 full-time jobs. And then the other thing with EB5 Direct is there's a concept under the regional center where they look at indirect jobs. So they look at the impact the economy has, and they look at indirect jobs, but they're not counted for this. So yeah, so definitely, significant requirements both in terms of dollar value and in terms of hiring employees. The other kind of last thing I'll mention with respect to EB5 is that when we look at E2, we spend often very little time on source of funds. So the requirement related to exactly where the money came from, even when you go back and look at the regulations under E2, there's nothing specific about source of funds. It's in the appendix where they kind of describe that these are the types of documents that you should have, but there's no specific language related to it in the regulations, other than you have to show that the money came from a legitimate source. While the regulations under EB5 don't say much more, unfortunately USCIS treats this as if they're doing an audit. So the an E2, like when we submit a case, when we take a case, when we move a case from E2 to EB5, we have to spend a lot of time making sure that the government will accept their source of funds. And in a lot of cases, it's going to be difficult. And that's why really planning, if you know that you're moving towards EB5, planning from the beginning is something that's really important, because it is often when we do EB5 petitions, the source of funds section is, hundreds, if not thousands of pages. So that is EB5 in a nutshell. So maybe the last thing that I'll just talk about EB5, the petition that's filed, it's an I-526 petition. If you're in the United States, you're going to file an I-485 petition, which is an adjustment of status, and if not, then you're going to do consular processing. On your I-526 form, just if we don't do your petition, you have a lawyer that does it. Just make sure that they check off the consular processing box. It's very, very important. You never ever should check the box of adjustment of status. You can always change it later, but it causes a lot of problems if you don't. And then 2 years after, this is a temporary green card, where you get it issued, and then 2 years later they will remove the conditions after you showed that you have created the 10 full-time jobs. Okay, so this example we're not going to go through. Now the last slide that I'm going to spend 2 minutes on this slide, but just other options that you should consider. family-based options. If you marry a U.S. citizen and other family, there are green cards available. Diversity lottery, if you're from certain countries, some countries are not eligible if they already have enough people in the country from that, people in U.S. from that country. Like for example, Canada is not eligible, but you should definitely apply for that. It's something that's done yearly. Every year we have a client that has won the green card lottery. EB2, EB3, sometimes an entrepreneur might start off as an E2, but then they might raise capital and then they're no longer 50% owner of their company, and they might be eligible for another green card, which is the company sponsoring them. Like their ownership could be so diluted by the point that they've sold off some of their shares that it could just be like any other company sponsoring them for a green card. H-1B has the ability to for self-employment. It's rare, but it's something that could be considered. When you're applying for these visas, these will kind of lump them together: dual intent and timing considerations. If you're here on a visa, if you're here on an E2, an O1, you have to really consider the timing, because those are non-immigrant visas that are not dual intent visas. So if you have to travel, if you have to renew the visas, they're all things that have to be considered. So you have to work out with your immigration attorney very, very closely how it is you apply for these, and make sure that you're applying for them so that you'll actually have time to renew, or maybe renew right before, etc. So let us go then to, so let's turn to, I know Kelly, there was an E2 question, if you could handle that one.
Yeah, I think I put it in the chat box. I'm not sure if it's a question everyone can see, maybe because I think it was asked in two places. But so the question is, can the investment be kind of, if you have a company that's already operating, can the investment come from money from the operation? So as similar to the EB5, as Ian was saying, the investment has to be your personal funds. So if you have a company, your company earns $100,000 a year, and then you take your profits and you pay for expenses, that's not investment for E2. So what would have to happen is, if you paid yourself a salary, if you took a distribution, you paid taxes on that money, and then you reinvested it into the United States, that would count as investment. So when you have a company that's already been operating and you haven't made any personal investments yet, you would need to be prepared to make a new personal investment into the company in order to get the E2. This question also asked about, can I invest a small amount, about 25,000, and then keep an amount, 100,000 in the business bank account. I think 25,000, there was a time when we did have E2 visas that were being approved with only 25,000 spent. I think I'd say for today, it's a very, very low amount. It really depends on the type of business. Is it service-based? Are you able to argue that you really have spent everything needed, for the company? But I think that generally we are advising people if they can spend closer to the $35,000 to $40,000 mark. I think that makes it stronger. Additionally, sometimes if you have a low amount like 25,000 spent and then a high amount as your working capital, sometimes officers don't like that. So I think 25,000 overall is or 30,000 even is a low amount. Yeah.
Yeah, and I agree, because I think that we definitely, because even when we did our E2, it was based on a very, very low investment amount, and for years we continued to process E2 applications in Toronto in particular with very, very low investment amounts. But then it just came a time where you could see that they changed their mind with respect to accepting those lower investment amounts, and now I find they only do it when the case has other compelling factors. Like we had one recently where the investment amount was quite low, but the person was a doctor and they were running a clinic that had all of these insurance contracts, that it was just so obvious that that job was going to, or that particular business was going to easily be able to hire US workers. So even though it was a very, very low investment amount, we didn't worry about the application getting approved. But I think generally speaking, their consulates are just less and less swayed by the thought of, the thought that, it doesn't cost a lot to get this business up and running, so I didn't spend a lot. They're just not, the one good thing with, if your application is denied because your investment amount is low, you can always reapply. But better to better to get it the first time around. Rather than wait. Unfortunately, the one negative thing with E2, when I applied for my E2, I had it signed a 1-year lease that was $1,700 a month that I didn't need. I didn't have any clients and I didn't need an office. But I spent that money for 1 full year, but it did help me, I think, get the visa. So perfect, excellent. So I think we have answered all of the questions. So that is great. Thank you very much, Kelly. Thank you very much, Michaela. That was fantastic. And as I said, we will send out a copy of the presentation, a link to future webinars, and an E1 and E2 visa guide. And yeah, we look forward to seeing you perhaps at our next seminar next week. Thank you.